Hey guys, welcome to today's Legal 101. Being a Thursday, it's on environment and land law. What we're talking about today is tenancy agreements. And we are borrowing from a judgment by Justice Kariuki that was delivered in 2022. Now, before I get into the facts of the case, this is just to let you know that before you enter into a contract, just realize that you have freedom of contract. You have the right to put whatever it is you want in that contract. However, any contract that violates any provision of the law is illegal. Now on to the facts. We have two people, person A and person B. Person A is the owner of property, okay, owner of land. Person B is the lessee. Person B wants to lease out person A's property and plant some things like most people do, kukodi shamba ya mtu fulani. So in 2012, person B approaches person A and says, I want 1.25 acres of this property so that I can be able to plant my crops. And so they enter into an agreement for 2 years, 2012 and 2013. Mid 2012, person B says, is it possible to get another lease for 2014 and 2015? But the owner says, okay, fine. And for the first lease, he paid 15K. The second lease, he also paid 15K. Now, in September of 2013, the owner repossesses the land. And according to now person B, the owner harvests potatoes that don't belong to him worth 69K, does not allow person B to tend to his maize, which is yet to be ready for harvesting, and he says the cost of production was 66K, and allows his cows to graze on some of that maize, destroying maize valued at 9K. Okay, and so person B goes to the lower court because the value of the property was 160 something. I mean, the value of the subject matter was 160 something, 163K, and so he's awarded that. He's also awarded general damages because it is felt that just to returning to his position before this violation. And so the owner of the property goes to court and says, first of all, whatever report you provided before the lower court to say that this is how much was valued is inaccurate, and gives various reasons, but the gist of it is that there was no proof. Okay, and then says, number two, I've always wanted to refund you for the second term, 2014, 2015, you just refused. But in any case, the main argument here is that you did not obtain consent from the Land Control Board as is required under Section 6 of the Land Control Act. Okay, and that provision is that all transactions affecting agricultural land, namely sale, lease, mortgage, and exchange, are void for all purposes unless the Land Control Board for the area has given consent. So the owner is basically saying, you decided to come and cultivate on this land, but you did not go to the Land Control Board of the area to obtain consent. Yet ameshakula 15,000, okay? And so the matter is brought before Justice Kariuki, and so he has to look at Court of Appeal decisions because they are the ones that are binding upon him. And he says different benches of the Court of Appeal have decided very differently on this issue of Section 6. While some have really adhered to Section 6, others have talked about creation of a constructive trust, and we're going to see what a constructive trust is. And the reason why courts are able to deviate from what Section 6 strictly provides is because that section does not prohibit a court from exercising its equitable jurisdiction in a land dispute, okay? Because like we always say, things always happen on a case-to-case basis, and these ever-changing circumstances that perhaps could require a court to interpret a particular section differently, okay? So then, what is a constructive trust? It is an equitable remedy that is imposed by courts to benefit a person who's wrongly deprived. And an equitable remedy is a remedy developed by courts from time to time to provide more flexible responses to the ever-changing landscape. Now, for there to be a constructive trust, and also based on what we have seen on case law, then there has to be a question of whether or not there was a written contract. You see, not many people actually write down the terms of a contract. You will just find person A has sold to person B. Person B has lived there for many years. Nobody executed anything. But actually, go on the ground, person B is living there with their family. So person A might out of nowhere come out and say, oh, this is my land, etc, etc. But you see, person B will be protected if the court can say, okay, let there be a creation of a constructive trust. Okay, something to protect this person who ideally should have followed procedure to ensure they actually have legal ownership of this property, but they did not. But if we allow person A to win, okay, there will be unjust enrichment on the part of person A. So what can we do to protect person B's interest? Okay, and that's where the issue of constructive trust comes in. But in this present case, Justice Kariuki said, there was actually a written instrument. There were these two leases. There was nothing that was stopping this lessee from going to the Land Control Board to have it considered and for him to obtain a consent. There was nothing that was stopping him, which is different from constructive trust, where you would say there was actually no agreement. It was word of mouth, and we have lived here peacefully until something changed. So the court said in this particular case there was no constructive trust, and so the court scraped the orders that the lower court had provided and actually said, I'm going to apply section 6 as is. You did not get the Land Control Board consent, and therefore that transaction, those agreements were null and void. But I'm going to give you 15k for the second period, considering this termination happened towards the tail's end of the first lease agreement. So that's as far as today's Legal 101 goes. Let me know if you have any questions. Thank you for engaging with the other videos. And see you tomorrow for tomorrow's Legal 101 on constitutional and human rights law. Bye.